A patent protects a new useful invention. To be eligible, an invention must satisfy three statutory bars. Patentable subject matter. It must fit into one of the four categories listed in 35 United States Code Section 101 process machine manufacture or composition of matter. Courts exclude abstract ideas, natural laws, and products of nature, for example, a newly discovered gene. Novelty. The invention cannot have been publicly disclosed before the filing date. Think of it like a first-to-show race. If someone else posted the same idea on a blog yesterday, you lose. Non-obviousness. A person of ordinary skill in the art POSITA must not find the invention obvious when combining prior art references. Imagine a puzzle. If the solution can be assembled by simply putting two known pieces together, it is obvious. Statutory requirements: 35 United States Code Sections 102 to 103, 112. Written description: you must describe the invention so that someone skilled could make it. Enablement: the description must enable the work without undue experimentation. Definiteness: claims must be clear and precise. Vague claims are like blurry street signs that cannot guide drivers. Example: a startup creates a new type of electric bike battery that uses a graphene-based electrolyte. The battery is a machine, the battery pack, and a composition of matter, the electrolyte. The company files a provisional application before any public demo, ensuring novelty, and drafts claims that specifically describe the graphene concentration, satisfying enablement and definiteness. Number 2, patent term, maintenance fees, and enforcement metrics. Patent term: in the United States, a utility patent lasts 20 years from the earliest non-provisional filing date. 35 United States Code Section 154. Design patents last 15 years from issuance, post May 13, 2015. Think of the term as a lease on exclusive rights. After the lease ends, anyone can use the invention. Maintenance fees. To keep a utility patent alive, owners must pay fees at 3.5, 7.5, and 11.5 years after issuance. Currently $800, $1,800, $3,800 for large entities. Skipping a fee causes the patent to lapse, similar to not paying property taxes and losing ownership. Enforcement metrics. Litigation success rate: the percentage of cases where the patentee obtains a favorable judgment. Infringement damages, often calculated using reasonable royalty or lost profits methods. Enforcement cost-benefit ratio: estimated recoverable damages minus litigation cost divided by litigation cost. A ratio greater than 1 indicates a financially sound enforcement. Example: a biotech firm holds a patent on a CRISPR delivery vector. After 5 years, it evaluates whether to pay the 3.5-year maintenance fee. The firm forecasts $12 million in licensing revenue, probability 80%, and $500,000 in litigation costs. Expected net benefit equals 0.8 times $12 million minus $500,000, which equals $9.6 million minus $500,000, resulting in $9.1 million, justifying the fee payment. Registration steps: United States focus. Search, check United States Patent and Trademark Office's TESS database to avoid conflicts like checking a phone book before naming a new restaurant. Application filing: submit a TES form with the mark, goods and services, nice classification, and specimen of use. Examination: United States Patent and Trademark Office attorney reviews for conflicts, descriptiveness, or genericness. Publication: mark appears in the official gazette. Third parties get 30 days to oppose. Registration: if no opposition, the mark registers. For intent to use applications, a statement of use is required before registration. Infringement likelihood analysis uses the Polaroid or Sleekcraft factors. United States courts. Strength of the mark: fanciful or arbitrary marks, for example Xerox, are stronger than descriptive ones. Similarity of the marks: visual, phonetic, and conceptual similarity. Similarity of goods and services: are the products in the same market? Evidence of actual confusion: consumer surveys, misdirected communications. Marketing channels: same stores, websites, advertising mediums. Purchaser sophistication: expensive, high-involvement purchases lower confusion risk. Defendant's intent: if they tried to ride on the plaintiff's reputation, likelihood rises. Likelihood of expansion: if the parties may later offer overlapping goods. Example: Apple for computers is a strong arbitrary mark. A new company sells Apple-branded headphones. Using the Polaroid factors, a court would likely find high infringement risk because the marks are identical, the goods are related electronics, and there is evidence of consumer confusion. Trademark dilution, classification, and damage quantification. Dilution occurs when a famous mark's distinctiveness is weakened, even without causing confusion. Blurring means the famous mark's identity becomes less unique, as it is linked to unrelated goods, for example, Google used for a line of coffee. Tarnishment means the mark's reputation is harmed by association with inferior or scandalous products, for example, Mercedes on a low-quality knockoff. Classification: courts categorize marks as famous if they are widely recognized by the general consuming public. The Lanham Act Section 43C provides the statutory basis. Damage quantification methods. Actual damages are lost sales or profit attributable to dilution, hard to prove. Statutory damages up to $250,000 per infringement for famous marks, United States. Profits of the infringer are disgorgement of profits earned from the diluting use. Equitable relief includes injunctions, disgorgement, or corrective advertising. Example: a luxury fashion house, Gucci, discovers a budget clothing line called Gucci Style sold online. The brand files a dilution claim. Because Gucci is famous, the court can award statutory damages of $250,000 per defendant, even if no actual confusion occurred, and grant an injunction to stop the use. Copyright protects original works of authorship fixed in a tangible medium, such as literary, musical, artistic, software, and multimedia works. It grants exclusive rights to reproduce, distribute, create derivative works, publicly perform, and display the work. Ideas, facts, and functional items, for example, software algorithms, are not protected, only the expression is. Duration: United States. Works created after January 1, 1978 are protected for the life of the author plus 70 years. For joint works, protection lasts 70 years after the last surviving author dies. Works made for hire are protected for 95 years from publication or 120 years from creation, whichever is shorter. Pre-1978 works follow different rules, generally 95 years from registration. Economic valuation models. Income approach is the present value of expected future cash flows from the work. V equals the sum from T equals 1 to N of cash flow sub T divided by open parentheses 1 plus R close parentheses to the power T, where cash flow sub T is the cash flow in year T, R is the discount rate, and N is the number of years of expected revenue. Market approach compares recent sales or royalties of similar works, known as comparable transactions. Cost approach sums the cost to recreate the work, which is rarely used for creative assets. Example: a music publisher estimates that a hit song will generate $1 million in royalties over the next 10 years, with cash flows growing 3% annually, using a discount rate of 8%. Year 1 cash flow equals $1 million divided by 10, which is $100,000 simplified. Applying the income approach formula yields a present value of approximately $730,000. This valuation can be used for licensing negotiations or as collateral. Comparative analysis of intellectual property remedies, injunctions, damages, and account of profits. Injunction: to stop ongoing or future infringement. Courts consider irreparable harm and balance of hardships. Damages: actual or statutory, when monetary loss can be proven, or when statutory damages are preferred, for example, for willful infringement. Account of profits: to deprive the infringer of gains earned from the infringement. Actual damages equals lost profits plus reasonable royalty. Statutory equals up to $150,000 per work in the United States, $250,000 for willful infringement. Profit equals revenue minus cost of goods sold minus allocated overhead. Injunctions are forward-looking, protecting future market position, but require a showing of irreparable harm. Damages are backward-looking, compensating for past loss, easier to quantify when sales data exist. Account of profits can be punitive and is useful when the plaintiff cannot prove exact loss, but can show the infringer's earnings. Example: a software company discovers a competitor copy pasting its code. The plaintiff files for a preliminary injunction to halt distribution. Actual damages based on a 5% royalty on the competitor's $10 million sales, $500,000. An account of profits showing the competitor made $2 million profit on the infringing product, of which $1.5 million is attributable to the copied code. The court may grant the injunction, award $500,000 in damages, and order disgorgement of $1.5 million. 7. Licensing strategies and royalty rate determination, including NPV calculations. Licensing strategies. 1. Exclusive license. Only the licensee may exploit the IP, higher royalty but risk of dependence. 2. Non-exclusive license. Multiple licensees, lower royalties but broader market reach. 3. Sole license. The licensor retains limited rights, for example, can use the IP themselves. 4. Cross-licensing. Two parties exchange licenses to avoid litigation, common in tech. Royalty rate determination. Revenue share model. Royalty equals % of sales, for example 5% of net sales. Profit share model. Royalty equals % of profit after costs. Fixed fee model. Lump sum payment, often for short-term or limited scope use. Hybrid model. Combination of fixed fee plus per unit royalty. Factors influencing rate: market size, exclusivity, remaining patent life, substitutability, and bargaining power. NPV, net present value calculation for a license. NPV equals the sum for T equals 1 to N of open parenthesis R sub T times R royalty minus C sub T close parenthesis, divided by open parenthesis 1 plus kappa close parenthesis to the T power, minus I. Where R sub T equals projected revenue in year T. R sub royalty equals royalty rate decimal. C sub T equals incremental costs to the licensee, manufacturing, distribution. Kappa equals discount rate, cost of capital. N equals license term, years. I equals upfront licensing fee, if any. Example: a biotech firm grants a non-exclusive license for a patented drug delivery technology. Projections: $20 million revenue in year 1, growing 10% annually for 5 years. Royalty rate equals 6%. Incremental cost equals 2% of revenue. Discount rate equals 12%. No upfront fee. Calculate NPV. Year 1, open parenthesis 20 million times 0.06 close parenthesis minus open parenthesis 20 million times 0.02 close parenthesis equals 1.2 million minus 0.4 million equals 0.8 million. Discounted cash flow year 1 equals 0.8 million divided by open parenthesis 1.12 close parenthesis to the 1 power equals 0.714 million. Repeat for years 2 to 5 with revenue growth. Summing discounted cash flows yields NPV approximately $3.1 million. The licensor can compare this NPV to alternative strategies, for example direct commercialization, to decide. Portfolio valuation approaches: 1. Sum of the parts SOTP. Value each IP asset individually using income, market, or cost approach and add them together. 2. Real options analysis treats each IP right as a financial option, for example the right to commercialize. The Black-Scholes formula can be adapted. V equals Sn of D sub 1 minus K e to the power of negative RT times N of D sub 2, where S is present value of expected cash flows, K is exercise cost, R is risk-free rate, T is time to expiry, and N is cumulative normal distribution. 3. Monte Carlo simulation, model uncertainty in cash flow forecasts, discount rates, and market adoption to generate a distribution of portfolio values. Risk assessment dimensions: legal risk, validity challenges, jurisdictional enforceability, expiration dates. Commercial risk, market demand, competition, technology obsolescence. Operational risk, ability to enforce rights, maintain fees, and monitor infringement. Strategic risk, alignment with corporate goals, synergy with other assets. Risk-adjusted valuation: apply a risk discount factor, RDF, to the raw NPV. V adjusted equals NPV times open parenthesis 1 minus RDF close parenthesis. RDF can be derived from a weighted average of risk scores. For example, legal 30%, commercial 40%, operational 20%, strategic 10%. Example: a tech company has 3 patents with NPVs of $5 million, $3 million, and $2 million, total $10 million. Risk scores: patent 1, legal 10%, commercial 20%. Patent 2, legal 30%, commercial 40%. Patent 3, legal 20%, commercial 30%. Compute RDF for each colon. Patent 1 RDF equals 0.1 times 0.3 plus 0.2 times 0.7 equals 0.17. Adjusted value equals $5 million times 0.83 equals $4.15 million. Patent 2 RDF equals 0.3 times 0.3 plus 0.4 times 0.7 equals 0.37. Adjusted value equals $3 million times 0.63 equals $1.89 million. Patent 3 RDF equals 0.2 times 0.3 plus 0.3 times 0.7 equals 0.27. Adjusted value equals $2 million times 0.73 equals $1.46 million. Portfolio risk: adjusted value approximately $7.5 million. 9. International IP treaties and their impact on cross-border business strategies. Okay, treaties. Paris Convention, 1883, establishes national treatment, right of priority, 12-month for patents, 6-month for trademarks and designs. Allows a company to file in one country and claim the original filing date in others. Berne Convention, 1886, automatic copyright protection across signatory countries. No registration required. Minimum term life plus 50 years, many have adopted life plus 70. Patent Cooperation Treaty, PCT, provides a unified filing system for patents. An international application gives the applicant up to 30 to 31 months to enter national phases, deferring costly country-by-country filings. Madrid Protocol, 1995, centralized trademark registration. One application can cover multiple designated countries, reducing administrative burden. TRIPS Agreement, 1994, World Trade Organization, sets minimum standards for IP protection in trade agreements. Includes enforcement provisions and anti-counterfeiting measures. Strategic implications. Priority claim. A United States startup can file a provisional patent, then within 12 months file PCT and later national applications, preserving the early filing date globally. Cost allocation. Using PCT and Madrid allows companies to stage expenditures based on market potential, rather than paying for all jurisdictions up front. Enforcement. TRIPS obliges member states to provide legal remedies. Firms can rely on local courts to enforce rights, but must adapt to procedural differences. Portfolio harmonization. Aligning filing families across treaties simplifies management and reduces gaps where competitors could exploit unprotected markets. Example: an apparel brand wants protection in the United States, European Union, and Japan. It files a trademark in the United States, then uses the Madrid Protocol to designate the European Union and Japan within 6 months. The priority date, United States filing applies, preventing a later competitor from registering a similar logo in those regions. 1. Abstract idea. Laws of nature, natural phenomena, and abstract mathematical formulas are not patentable. Example: a claim that merely covers the concept of using a computer to match buyers and sellers without specific technical implementation is abstract and thus ineligible. 2. Law of nature. Pure scientific principles cannot be patented. Example: the gene sequence for the BRCA1 mutation is a naturally occurring DNA segment. The sequence itself is a law of nature. 3. Natural phenomenon. Naturally occurring materials are excluded. Example: a newly discovered mineral found in a mountain cannot be patented. 4. Product of nature. If the invention is a naturally occurring substance isolated without alteration, it is ineligible. Example: isolating a plant-derived oil that exists in nature without modification cannot be patented. The answer should also mention that adding an inventive application or machine-specific step can overcome these bars. Calculate annual royalty cash flow. $10 million times 4% equals $0.4 million. NPV equals sum from T, equals 1 to 5 of 0.4 million divided by 1.1 to the t equals 0.4 m divided by 1.1 plus 0.4 m divided by 1.1 squared plus 0.4 m divided by 1.1 to the fifth. Approximately 0.364 million plus 0.331 million plus 0.301 million plus 0.274 million plus 0.249 million equals 1.52 million. Thus, the NPV of the licensing stream is approximately 1.52 million. Injunction is a court order to stop the infringing conduct. It is forward-looking, intended to prevent further damage, and requires the plaintiff to show irreparable harm and a balance of hardships. No monetary compensation is directly awarded, but the business may suffer immediate loss of sales. Account of profits is a monetary remedy that forces the infringer to surrender the profits earned from the infringement. It is backward-looking, calculated by subtracting the infringer's attributable costs from the revenue derived from the infringing activity. It can be larger than actual damages, especially when the plaintiff cannot prove exact loss. Both remedies can be granted together. The injunction halts future infringement, while the account of profits compensates for past gains. 1. Extended decision time. The PCT gives up to 30 to 31 months from the priority date before entering national phases, allowing the firm to assess market potential and secure financing before incurring costly country-specific filing fees. 2. Unified search and examination. The International Search Report and optional preliminary examination provide early insight into patentability, enabling the firm to amend claims early and reduce the risk of later rejections in individual jurisdictions.